Swayam Prabha. Digital India. Educated India.
Hello dear students, today I am here to discuss with you a chapter on revision. That is revision, that is very small topic, that is very, it is no doubt it is small chapter, not so lengthy, but still it is very relevant from assessment point of view. So let us start. So we are discussing revision. So kindly first of all note that in this section, this chapter basically revolves around two sections of the Income Tax Act 1961, and these sections are section 263 and section 264. These are very much relevant in this regard. So you should be keeping that in mind. And you should know that while discussing the chapter on appeals, we had already discussed that that in case the assessee is not satisfied with the orders passed by the assessing officer, then four ways were there. I think you are aware that four ways were there. First was to move to the Commissioner of Income Tax Appeals, and secondly was to move to the ITAT. And in case some question of law is there, in that case the assessee was free to file a writ, to move to the High Court, Honorable High Court, and lastly to move to the Honorable Supreme Court. But let us suppose now the time period to file an appeal to CAT appeal is over. That has, you may say, that is over. And now what to do? Now assessee, what the assessee can do, and in case he was unable to give some reason, some genuine reason, some, you may say, good ground, and his delay was not condoned by the CAT appeals, then what to do? In that case, assessee may also move for revision. But kindly note that we are discussing these two sections. And what are these two sections? Under section 263, we will be dealing with the situations, with the cases when what is there? You may say when the decision of the AO, when the decision of the assessing officer is against the, you may say, is not in favor of the department. So those cases have been dealt in with, you may say, in section 263. And when the decision is basically in favor of assessee, so those cases have been dealt in under the section 264 of the Income Tax Act 1961. So you should be aware that 263 deals with, I am showing you the details. First of all, let us discuss section 263. Now, what is there in section 263? Kindly note, it deals with the revision of orders which are prejudicial to the revenue. Meaning thereby, kindly note this wording. Some orders are there, but as per those orders, as per the implications of those orders, the revenue, you may say tax revenue that is coming to the department, we think the officer think that it is not as per norms, rather it is prejudicial to the interest of the revenue, meaning thereby that otherwise it would have been, the revenue would have been much more. So in that case it is there. So I am discussing with you those cases. Now kindly note, in case the principal commissioner, or in case the commissioner, in case principal commissioner of income tax or commissioner of income tax, CIT, these officers, any of them, he or she is of the opinion that, first is that any order which has been passed by the assessing officer is prejudicial to the interest of the revenue. I think I have explained it to you that it is not in the interest of the revenue. That more amount would have been collected from the assessee, but now as a result of this order, the amount accruing to the department will be, you may say, less. So in that case, principal commissioner or commissioner may start revision of orders under section 263. Now secondly, in order to do that, kindly note, we will be studying that what types of orders are considered to be prejudicial to the interest of the revenue. But in case principal commissioner or commissioner wants to do that, then it may be done. He is free to do so. But before doing so, an opportunity of being heard should be given to the assessee, and kindly note, and a detailed inquiry may also be made before finalizing the final order, before revising the order. And after that, kindly note that then the order may be passed, a new order may be passed, and in that case, what may be there, what may be the consequences. Kindly note, even the earlier tax liability may be enhanced. That means it may result in enhancing, or enhancing means increasing or modifying the earlier assessment that was that was made by the assessing officer. Or even in case some major you may say deficiency is there, in that case what will happen? In that case, even those orders passed by the assessing officer may also be cancelled, and after cancelling that assessment, fresh assessment may be directed. So this is the you may say this is the role of this section. And you may say that on many occasions it may result in some grievance of assessee. Assessee may complain against this as his you may say tax liability has been increased. So in that case, what are the options available to the assessee? So dear students, please keep in mind that in such case, assessee is free to move to the ITAT. Assessee is free to move to the ITAT. I think what is ITAT? What is the full form of ITAT? Income Tax Appellate Tribunal. I think you are much aware regarding that, and we have already discussed the detailed provisions regarding ITAT while discussing the chapter on appeals. So these are the cases. Kindly note that I have just told you that the principal commissioner or commissioner may revise the order in case it is felt that it is erroneous or it is prejudicial to the interest of the revenue. Now what are the cases? We should know that when the order passed by an AO, when the order passed by the assessing officer shall be deemed to be erroneous or prejudicial to the interest of the revenue. We should know those cases also. So now what are those cases? Kindly, my dear students, kindly keep in mind that 4 types of such cases might be there, and we are discussing these, and you should be careful. First is when it is found. First category is when it is found that order has been passed by the assessing officer. Assessment order has been duly passed by the assessing officer, but when it comes into picture, it is found that the order was passed without making detailed inquiries or without making detailed verification, which should have been made keeping in mind the you may say fact and figures, circumstances of the case. A detailed inquiry, a detailed verification was needed. That was needed, but the assessing officer has failed to conduct such inquiry or make such detailed verification that should have been made. So in that case, such orders shall be deemed to be erroneous, and these will be deemed to be prejudicial to the interest of the revenue. It deemed to be means against the interest of the revenue. So dear student, this was the first part. Now what is there in second part? Again, kindly note that in second part, when it is found, when it comes into the picture that assessing officer has provided, assessing officer has given, assessing officer has allowed, you may say, some sort of relief to the assessee, some sort of relief to the assessee, but that relief has been given to the assessee without inquiring into the claim. Again, it will fall in the category of orders deemed to be erroneous or prejudicial to the interest of the revenue. What is required? What is required that some inquiry should be made. Some inquiry should be made in the claim that has been in the claim made by the assessee, and only after dealing with that, only after studying that claim in detail, the order should have been passed. The order should have been, you may say, made, but it was not done. It was not the procedure, the proceedings, you may say, didn't move in that direction. So again, it will be considered to be erroneous and prejudicial to the interest of the revenue. I think 2 points are clear to you, my dear students. Now we are coming to the third point. Again, kindly note that in case we know the apex authority, we know the topmost authority in case of income tax, in case of direct tax, it is CBDT. Now, what is CBDT? I think you are aware, and you should be aware. It is Central Board of Direct Taxes. Now, kindly note that some order, some direction, some instructions were made. Kindly note, some instructions or directions or order was made by the CBDT under section 119 of the Income Tax Act 1961. And assessing officer has, you may say that otherwise it should not be there, but let us suppose that assessing officer has passed the order, assessing officer has made the assessment, passed the assessment orders, you may say, but he has not considered, he has not kept in mind the directions, orders, instructions made by the CBDT under section 119. In that case, again, such order will be deemed to be erroneous or prejudicial to the interests of the revenue. So kindly keep in mind. Now, my dear students, the last part, the last fourth part, when again the order will be deemed to be erroneous and prejudicial to the interest of the revenue. Now, what is there in this part? Kindly note that again in this fourth, you may say, sub part, assessing officer has made some decision. Assessing officer has issued an order. He has completed the assessment. But again, he has completed the assessment, and kindly note that order has not been passed in accordance with any decision. Some decision was there, but order has not been passed in accordance with the decision, which is prejudicial to the assessee, and it was rendered by the jurisdictional High Court or Supreme Court in case of the assessee or any other person. But something you should note, that main point is jurisdictional High Court. Let us suppose the person is living in Punjab, and the jurisdictional High Court, that is Punjab and Haryana High Court, that is located in Chandigarh. So some decision was there, and the decision given in that case will be applicable to the assessee. Let us, at a similar point, kindly note that some other high court has given the decision in some other way, but that would not be discussed, that would not be applicable to our assessee, who is, you may say, resident in Punjab. So our jurisdictional High Court is, you may say, Honorable High Court, that is Punjab and Haryana High Court. So, but in case some decision was passed by the Supreme Court, in that case it is clear. I think you are aware that other decisions made by the Supreme Court that is applicable pan India, that is applicable in entire in entire India. So that is there, that is there. So in case order has been passed by the assessee, but it is not in accordance with the decision which is prejudicial to the assessee rendered by jurisdictional high court or Supreme Court. So in that case, again it will be treated as, it will deemed to be an order erroneous and prejudicial to the interests of the revenue. Now again, it is we are continuing with section 263. I have already told you that mainly two sections are there, section 263 and section 264. Again we are continuing with the same section. Now kindly note that in case the order with which we are dealing, that has been passed by the assessing officer, but some part of that was the subject matter of any appeal, then what would be there? Kindly note that in that case, the powers of principal commissioner or commissioner under section 263 subsection 1 of the Income Tax Act 1961 shall extend. The powers will increase, and these powers shall be deemed always to have extended to such matters. It is implied that powers will extend and shall be deemed always to have extended to such matters as had not even been considered and decided in such appeal. So you see the power of, you see the you may see the spirit of this section, that in such cases the powers of commissioner or principal commissioner will automatically increase, will automatically extend or deemed to extend, and in these will extend to such matters which had not been considered or decided in appeal, in an appeal that was made by the assessee. Now one main issue arises ki what is the meaning of record. It should be noticed that the term record shall include and shall be deemed always to have included all records relating to any proceedings under the act that are available with the principal commissioner or commissioner when it is basically at the time of examination by the principal commissioner or commissioner. So when at the time of examination by the principal commissioner or commissioner, whatever is record is available, so that will be considered, that will be that document, that set of documents, that paper or anything that is there, that will be included under the definition of record. So it should be noted. Now again, kindly note that what is the time limit? What is the time limit of this revision? What is the time limit? You see, some time limit, some maximum time limit should be there. Otherwise, the work of income tax department would become, you may say, very cumbersome. It is already very complex and they are very overburdened. But still, it will further increase. In case no time limit is there. So, what are the provisions regarding time limit? Kindly note. First of all, no order shall be made after the expiry of 2 years from which date? From the end of the financial year in which the order sought to be revised was passed. So kindly note that from let us suppose the order was passed in November 2000, you may say November 2019. Then the financial year will end on it will end on 31st of March 2020, and from that year, from the end of the financial year, let us suppose it will be up to March 31st 2022. So no revision, no order of revision may be issued after that. Now again, one thing you should also keep in mind, what is that? When we are calculating, when we are computing the period of 2 years, as I have already told you, in that case, the time that has been given by the department to the assessee, as I have already told you that some opportunity to the assessee should be given. He must be allowed to give his or her explanations, his or her details, or some other issues relating to the matter. So this time, and the and any period during which the revision proceedings were stayed by, some stay was there by an order or injunction of the court. This period, my dear students, these two types of periods will be excluded. These will not be considered. So basically, it is in favor of the assessee only. So now third point. What is the third point? Kindly note the time limit. As I have already told you, the time limit of 2 years, which we are discussing. This time limit will not be applicable. This time limit will not apply. It will not apply. In which case? In case, it is very relevant. In case the principal commissioner or commissioner is there, he has to give effect. He has to basically implement a finding or direction that has been contained in the orders of the ITAT. ITAT, I think you know that Income Tax Appellate Tribunal, Honorable High Court, and Honorable Supreme Court. I think it is clear that some finding is there, or some direction has been made by these authorities. Four appellate authorities are there: CIT appeals, then ITAT, then High Court, then Supreme Court. So in this case, other than CIT appeal, any direction is, in case any direction is received by the other three authorities, that is ITAT, High Court, or Supreme Court, and principal commissioner or commissioner, they are just, you may say, they are just giving it effect, they are just implementing it, then this time limit of 2 years will not be applicable. So that was there regarding 263, section 263 of the Income Tax Act 1961. Now let us move to the next section. Now let us move to the second category, that is revision of other orders. Now what is covered under revision of other orders, and what is the relevant section? You know that it is basically section 264 of the Income Tax Act 1961 that deals with that. Now kindly note that we have already discussed the provisions relating to the cases which were prejudicial, some erroneous thing was there, or which were prejudicial to the revenue. That we have already discussed in section 263. Now in case of any other order other than those orders which have been passed by any subordinate authority, including the deputy commissioner appeals. So in that case, what will be there? In that case, kindly note, in that case, it may be so that principal commissioner or commissioner may either on his own motion, without receiving any application from you may say applicant or assessee, they may do so, they may initiate the proceeding on their own also, or they may start the proceeding on receipt of an application from the assessee. Then what may be there? That they may call for the record of any proceedings under the act in the course of which some order was passed. Why we say that it is basically in favor of assessee? Why do we say so? As in such cases, some order was passed by the assessing officer, you may say some subordinate authority, but principal commissioner or commissioner either on their own, but mostly what is there? But mostly on an application from the assessee, they may call for the detailed record. of some case or some proceedings in the course of which the said order was passed. Now, then what will happen? They may, as I have already told you, principal commissioner or commissioner, he may make detailed inquiries. He may make detailed inquiries, and after making detailed inquiry, principal commissioner of income tax or CIT, that is commissioner of income tax, he may pass some order, some you may say revised order as he thinks fit. So it is also there. Again, we are dealing with section 264, it is continuing. But kindly note, my dear students, that no revision is possible if a period of 1 year has expired from the date of the order that is sought to be revised, that is sought to be revised by the assessee. Kindly note, in the previous section it was 2 years, but in this case it is 1 year from the date of the order. So kindly note, again, if the application for revision, I think you might be aware that fee is rupees 500. Rupees 500 fee is there today. As on today, the rupees 500 fee is payable, and it is to be paid by the assessee, and it must be made within 1 year. I have already told you just now, from the date on which order in question was communicated to him, or the date on which he otherwise comes to know regarding this decision, whichever is later. So these must be kept in mind. Okay, I think it is clear to you that one application should be moved along with a fee of rupees 500, and it must be moved, it must be made within 1 year. From which date? In two types of dates you should remember. The date on which the order was communicated to him, that is sought to be revised, or the date on which the assessee comes to know of it, he becomes aware of it, whichever is later. Then again, what will be there? You see, in case the period of 1 year is over, and assessee, you may say, wants to get his orders revised after 1 year. I have already told you that the maximum time limit is 1 year. Suppose he makes an application, and he proves, he says something, some medical ground may be there, or some other sufficient ground may be there, and he is able to satisfy whom he should satisfy, the principal commissioner or commissioner. He is satisfied that really assessee was prevented by some sufficient cause, only due to that reasonable ground, that sufficient cause, the application couldn't be filed within that period of 1 year, and principal commissioner or commissioner is satisfied. Then in that case it is okay. In that case, principal or commissioner income tax may admit the application even after expiry of 1 year. Now, again, kindly note that in case the order is passed by the principal commissioner or commissioner, and they have declined to interfere in any proceeding, then it shall not be deemed to be an order prejudicial to the assessee. It should be kept in mind. Sometimes it may be there, it may be so assumed, but it should not be so assumed. It is but clear that if an order is passed by the principal commissioner or CIT, Commissioner of Income Tax, refusing to interfere in any proceeding, then it is not so that it is an order prejudicial to the assessee. It can't be assumed as such. Now, my dear students, now next, the cases, the circumstances where no revision can be made, where no revision is possible. Now, what are these cases? Kindly note that principal commissioner or commissioner income tax can't revise any order. They are basically not empowered to revise any orders in these cases. Basically, three types of cases are there. Now, let us deal with that. Let us study. Now, first is in case an appeal against the order lies to the commissioner appeals. As you already know that appeal may be made. Appeal against the order is there to CIT appeals or ITAT but that has not been made. And kindly note, we have already discussed that when time is over, only in that case the assessee may move an application for revision. But now think that appeal may be made. That is very much there. That is very much there in grounds of appeal, and even the appeal may be made to the tribunal, but it has not been made, and the time within which such appeal could have been made by the assessee, it is still available. It has not expired, or in case of an appeal to tribunal, the assessee has not waived his right to appeal. So in such a case, no revision can be made by the principal commissioner or commissioner of income tax. Now second, it is very simple that in case the order is pending on an appeal before the CIT appeals, again in that case principal commissioner or commissioner, they will not be empowered to revise the orders. Last category, third category, in case the order has been made but it is subject to an appeal to the commissioner appeals or appellate tribunal. So again in this case no revision is possible. Revision can't be made in this case also. Now what are the provisions regarding limitation of time for revision of orders by principal commissioner or commissioner under this section, that is under section 264. Kindly note that in case that it is obligatory, it is a responsibility of the principal commissioner or commissioner to pass an order within a period of 1 year, and from which date? From the end of the financial year in which application is made by the assessee for a revision. So it should be kept in mind. I have already discussed this thing with you, so I think it is clear to you. Then kindly note again, this is the time period of limitation. I think we have already discussed this, that in case some opportunity of reheard was given to assessee, or the period during which some stay from any court was there, or some stay of order or some injunction was there, so this period will be excluded. Similarly, again we had already discussed that in case some finding is there, in case some direction has been made by the appellate tribunal, honorable high court, honorable supreme court, and the principal commissioner or commissioners are basically implementing that, are basically giving effect to that finding or direction given by these you may say these appellate tribunal, honorable high court and honorable supreme court. In that case the time limit which we have just discussed will not be applicable. Now with this chapter on revision is over, and I think that it is clear to you. I have tried my best to make you aware regarding various provisions applicable as far as revision is concerned under the Income Tax Act 1961. Okay, thank you dear students, thank you.